It doesn't make any sense to get rewarded for continuing bad behavior if there's not some underlying other issue. Calls number 25, DCCR 0120. You were previously in court. You entered a plea of guilty to theft of material, aluminum, bronze, copper, or brass, a state jail felony, and that was a cap of 16 months in the state jail prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have.
I do, Judge. Are there any additions or corrections, explanations?
Yes, there is one issue that we would like to address regarding his statement.
Okay.
And Judge, that was in regards to his description of what happened as far as when he talks about them not stealing the copper. I think that was more of an issue of course, him not admitting that they were caught in the act. And this was something that was after the fact that he was still in the truck. He understands, how that may have sounded the way he expressed himself, and he totally takes responsibility for it.
So, Mr. Garcia, you said specifically in quotes, we did not steal anything from there.
We didn't, but we were caught there. We shouldn't have been there in the first place. I accept responsibility for what we were doing.
Well, what were you doing? What are you accepting responsibility for?
We showed up to look at the site. We were supposed to check it out. And that's when the cops showed up. I wasn't even in this. You know what I mean? I was there. I was in the truck when the cops pulled up, but I thought we were there on a job. So thought we were supposed to be working, we were supposed to win, but we hadn't yet. But I accept responsibility for what we're there to do. You know what I mean?
I don't know what you mean. That's why I'm asking you, because you're saying you were there in absolutely legit reason. And there was material in the back of your. Here's the thing. Now's the time not to gloss over it. Okay. Either you did it or you didn't do it.
Yes, ma'am. I did it. That's why. But
that's not what you're saying. You're saying you went there to do a job and the cops pulled up and y'all just got in trouble and you don't know why.
For 10 minutes. I mean, I don't know how else to put it in words. I did what I'm accused of being doing. I don't know how else to word it. She asked me to describe the situation. I did.
You said we did not steal anything from there. So did you or did you not steal?
I did.
Okay. So that's not what you just told me.
I don't know how else to word it. I hadn't gone in yet. We hadn't, but I don't say.
But the stuff was in, you had cut copper, a reciprocating saw, drills, and tools in the immediate area, in addition to multiple bundles of copper in the back of the truck. So how, I don't still understand. Did you steal the copper or not?
Yes, ma'am.
So now let's go to your criminal history and the fact that this isn't your first time to do this. You've got 5 prior felony convictions. You've received the max of 2 years state jail on 2 of them. 1, possession of a controlled substance and fraudulent use or possession of identifying information. You've received a 1-year state jail on theft of material. You've received a 2-year term on possession of a controlled substance. What all that means to me is that the deal that you received going on count 1 only, you could have been looking at 2 to 10 instead of just a state jail. And I don't agree. I think after seeing this, Ms. Malfino, is there something else that you either did or didn't know that would go into the state's position on that offer?
Judge, only that in my review of those priors, there were two state jails that did not need to be sequential. So I would agree that it could be a 3rd degree. I totally understand the court's confusion with something less than is what the 2 years that he has already received. And if we need to revisit that under a 3rd degree.
There's no facts or issue. Is there any, I guess any underlying facts or issues with the case that?
Not particularly, Judge. I mean, I know some of the people that run the AT&T, and I know this is a very menacing type of offense that then leads everyone else's bill to increase because we're all paying for what they're doing, but nothing particular because of this offense, Judge.
Okay, then I'm not going to accept that, that agreement. It doesn't make any sense to get rewarded for continuing bad behavior if there's not some underlying other issue.
And Judge, just to kind of point out there, mitigating circumstances for us. Mr. Garcia, he was dealing with a drug habit. That even why he's in custody right now from testing positive when he came into court. He has been struggling with that, but he has done some things or to try to move himself from the surroundings he was in, even while the case was pending.
I appreciate all that, but there doesn't seem any reason for me at all to agree to a 16-month sentence when this is his 6th felony offense, and it's the same type of offense. And the last time he was enhanced, or it was at least a 2-year in prison in TDC, not state jail. He's looking at 2 to 10 if he went to a jury, and I don't think 16 months is appropriate at all. I don't think that's what a jury in our community would think was appropriate for someone who continues to. Y'all go talk about it if you want to. I can reset it and you guys can kind of renegotiate and look at it and let me know. But at this point, I'm going to reject that offer.
Okay.
Perry Heard, Mr. Lewis.
Very heard.
Where's our guy from yesterday? It's just Monday. It is. We haven't seen. What about Mr. Reynolds? Mr. Reynolds. That's okay. Let's see. What about Mr. Parker? Okay, that's good. I'll let him. And Mr. Lewis, are you still working on some? Or are you
I'm
caught?
really just right on that thing. He doesn't talk over there.
I'm sorry.
I think Miss Marfina want to talk on one, so we need to hold.
I'll hold it for. Do y'all want to talk on that one real quick? Go ahead. I'd rather get.
Out of another hearing.
But he signed it, but he.
Yes, I'm just saying.
Okay.
I don't know how he
It could be a.
wanted to say no contest. He wanted to. Explain the law was for you. Oh, yeah. Did Philip sign them?
Mm-mm.
I'm sorry, Judge. You were thinking police laws, yeah.
Good morning. Are you Victor Charles Campbell Jr.?
Yeah.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
Here you are.
And it looks like we are going in 21-36426 and 22-39050, correct?
There's also a dismissal in 305.
And are we going on all of the counts or?
No, not on. We need to go on, well, in 36426, he will need to be true to the one enhancement paragraph in the indictment.
Okay,
And, one only in the other. Right.
all right, Mr. Campbell. In cause number 21-36426, you're charged with a 3rd-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from November 28th of 2020. The indictment further alleges that you were previously convicted of assault family violence, a 3rd-degree felony, December 5th of 2014. And how do you plead to that charge? So to the charge, let's start with just evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty? It's guilty or not guilty. Either you did it or you didn't do it.
I thought that's what the plea was.
There's a plea agreement means in my court, you either enter a plea of guilty or not guilty.
But
Mr. Campbell, I understand that you're already doing time for a murder and that you don't really care about what's going on today.
I'm saying I plead no content because he never even went over the indictment with me.
Yeah.
I find that hard to believe. So here's the
To
thing.
actually be honest, I just only been here for like about 30 days. So I got like 3 weeks or 30 days and about 2 weeks of being here.
Here's a picture
In Beaumont.
here.
Yeah.
So the nature of the crime, no cause number, and the magistrate, as far as the indictment, I never received one. And due to the fact of the nature of the charge of being from 2018, you have 5 years or 4 years to indict me to actually send that indictment. After
Sir,
I-
the
That's
allegation,
why I'm pleading no contest.
I'm not going to
I'm
allow.
fine guilty. It's fine.
Here's the thing. I don't have to accept any plea agreement.
Yes, ma'am.
Okay. So you can, in that evading arrest or detention case, if you go to trial and you're found guilty, it's habitual. You're looking at 25 to life. We can set it for trial. I'm not playing games and I'm not going to accept the disrespect. If you want me to follow this agreement and go along with the plea agreement and you can go on, do your time and be done with it, then we can get that done. But you're not going to show disrespect while we're doing it to me. Do you understand?
Yes.
So if you want to go forward, we'll go forward. If not, we'll set it for trial. Mr. Smith will get ready very quickly and we'll get your case tried within a month. And it'll be habitual 25 to life. What do you want to do?
It's 18 years.
No, the plea
If-
agreement.
If you go to trial, listen to me. If
Yeah,
you go to
fine.
trial and you're found guilty and your prior convictions, stop talking over me. If you go to trial and you're found guilty and those prior felony convictions are true, then you're looking at habitual 25 to life. Today, there's an agreement for something different. I'm glad to accept that if that's what you want to do, but you're going to either accept responsibility and plead guilty or plead not guilty.
Yeah.
That's your choices. So let's go back then and cause number 2136426. You're charged with a 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty?
That's what I'm saying. You saying assault family violence. The invading arrest is I
Listen.
plead guilty.
It's evading arrest or detention
But
with
what
the
are you
use.
looking at? I'm saying
I'm
Look.
looking at your indictment.
He's saying you got indicted for
I got that.
evading. In 2014, you
Right.
were
Hold on,
convicted of
this,
something
Mr.
else. Okay.
You've probably already tried. Let me take care of it this way. Give me just a second. Which one is being dismissed? 5-1? Or
39051.
Okay. Make sure you don't get my information mixed up with him.
Who's?
Or whoever that information is. I ain't gonna say his name on the record.
That's not me.
just a second. Well, it's taken care of. I should have 2 indictments. I just released. All right. Place that in front of your client, please. Now, that is cause number 2136426. That indictment alleges in paragraph 1 that you committed the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge?
I just pleaded no contest. She didn't want to accept no contest.
How do you plead to that charge? Guilty or not guilty? We're not going backwards, okay? I already told you you're not going to plead no contest.
Guilty or not, you plead guilty or not guilty.
So if I'm telling you no contest, what is this?
It's nothing and it's nothing. You're not allowed, I can take a plea of no contest or I cannot take a plea of no contest. That is up to the court. You're not legally entitled to plead no contest if there's a plea bargain. I'm telling you, if you want me to accept the plea agreement, you're going to plead guilty or not guilty. I've already told you that. I'm not going to tell you again. If I have to tell you again, guilty or not guilty,
I'm saying.
period. That's your, I'm
That's
about
saying
to
that
set
I'm
your
not-
case for
that's saying
trial.
that I'm not, that's basically saying that I'm.
We're not going to
guilty
argue the
or
law.
I'm not, or I'm guilty.
We're not arguing
That's
the law.
basically just saying that I
Doesn't-
state that.
I'm not going to
Go
argue
ahead.
the law
Fine,
with
no
you.
guilty. Just sign, go ahead.
I
Put it
don't-
as guilty. Go ahead. That's what y'all want anyway. That's
Listen,
fine. I'm cool, ma'am. Just go ahead. and
well,
get
you're
the
not,
guilty.
you're really not being cool and you're making me very frustrated.
Ma'am, I respect your call. Just go ahead and give me.
It, nothing here.
Pleaded guilty.
Mm,
There you
okay.
go.
So you plead guilty to evading arrest or detention
Yes,
with
ma'am.
use of a vehicle. Okay. The next count, the next paragraph that you're looking at says that you were previously convicted of assault, family violence, December 5th of 2014. Is that true or not true that you have that conviction
That's
on your
true.
record? Okay.
And that's not the same.
That's
case
okay.
As far as
Look-
evading arrest, ma'am. That's two different charges. So if you really want to be technical as far as being a habitual, that's called a repeated offender. But.
Exactly. And that's, listen, so Mr.
That's
Campbell, that's,
15.
wow.
I think.
Do you want to come sit up here and be the judge? You're so smart.
I don't know. If you needed some help, ma'am, I wouldn't mind.
I feel like I might because I'm not understanding. Mr. Campbell, you're getting a deal to go on count one only, which makes you a repeat. I get that you've been through this before and you understand what's going on, but you're making this more difficult. If you go to trial, you could be habitual. Today, if we take this great plea agreement, it's repeat. I understand that. I've been doing this for 30 years. Okay? So, did you enter your plea of guilty freely and voluntarily?
Guilty.
Did anybody force you to plead guilty today?
No.
Okay, so I have well, let's go to the next case then. In cause number, and here's that indictment. In cause number 22, 39050, you're charged with and in this case, we're just going on count one.
Count one only.
So in this case, we're going on count one only. So it's just the offense of tampering with physical evidence, a second-degree felony from November 28th of 2020. And how do you plead to that charge? Guilty or not guilty?
Pleading no contest, but guilty now.
So are you pleading guilty to this charge?
Yeah. that's
Okay.
actually-
And did anybody force you to plead guilty in cause number 22, 39050?
We just answered it.
I know I have to ask you in each case. It's required by law. It's required by law that I ask you that in every case.
Just pleaded guilty.
Okay. And nobody forced you to do that, right? Speak up so the record can take it
No,
down.
I think you did. You did, but let's go. So no.
Okay. So I have in both of those cases here on the tablet, some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed those, did you go over them with Mr. Parker? The documents on the tablet, y'all have that? And do you understand if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving any right to appeal? Yes or no, please? Do you understand that?
Understand what we signed, the document.
Okay, you have to answer out loud, yes or no, so that the record's clear that you understand, that I know you understand what you signed, okay? I'm not trying to, doesn't have to be that difficult. Just get in, get your deal and get out. You're making this way more difficult than it has to be. Do you also understand, if you're not a US citizen, that a plea of guilty or no contest could result in your deportation? If you're not a US citizen, could result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law.
So what this is,
I'm
Are you-
I'm required to ask everyone that. Are you a US citizen?
yeah,
Okay. State tender's number 1 in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Campbell is not competent?
But no, you're
You said.
I just printed the wrong thing.
She asked me if I thought that there's any MC warrant. I said, no, there's not. He's confident.
I just printed the wrong stuff. Did I print both of the
Give him the
certifications?
thing on that.
Sure.
Please. Please.
Okay. All right, Mr. Campbell, I'm going to find in each of your cases that you, Mr. Campbell, pay attention to me for a second, please.
Oh, fell, please. I ain't drinking,
Mr. Campbell, you ready?
Yeah,
In cause number 21-36426, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
so can you say that on record?
I'm on the
Yes.
record.
No, I'm saying say that how long I've been in custody.
I don't know.
I've been
I don't
in
have that
custody going on
information.
5 years.
Okay, you'll get all the credit that you are entitled to get.
Three months.
And cause number 22-39050, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of tampering with physical evidence. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These two cases will run concurrently, which means together at the same time and concurrently with any other sentence that you're currently serving. I have signed a dismissal as part of this agreement in cause number 22-39051. I'm handing you in both of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long it lasts, you can talk with your attorney. You can go back with the bailiff.
So do I get my papers for my time, sir?
Go back with the bailiff.
Is you gonna bring me my papers for my time,
They
sir?
have it in the jail.
Excuse me?
No, they have it at the jail. No. I told you.
You didn't tell me.
Why it wasn't that bad?
I mean, this one might be difficult, and Judge, this one's really gonna push you over the edge. Difficult with this move. Did you go over them with Mr. Parker? Brandon Clayton, Mr. Parker?
He was going to be a cold start date, probably. I knew that it's not. I almost put his stuff in this file. He's getting on me for missing stuff.
I know.
Very much.
Yeah.
Good body. TV.
Good morning, ma'am. I probably should have sat down. I need a break. Shouldn't do it.
Excuse me.
Good morning. Are you Brandon Jamal Clayton? And let's see, will your client waive the formal reading of the indictment and the motion?
Well, Your Honor.
Mr. Clayton, in cause number 26 DCCR 0229, you're charged with the third-degree felony offense of deadly conduct, discharging a firearm from January 5th of 2026. And how do you plead to that charge?
Good.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In that case, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand that?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in that case.
No objection.
It's admitted. Is there any evidence that Mr. Clayton's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to find you guilty at this time, of deadly conduct, discharging a firearm. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 22-39186, I have a first amended motion to revoke your unadjudicated probation.
Judge, count 1 is, if we did 1 and 8, 1 is failing to report, 8 is the offense for which you just pled guilty.
Thank you. This motion shows that you were placed on probation June 8th of 2022 for the offense of aggravated robbery, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
And the state's elected to proceed on counts 1 and 8. Count 1 alleges you violated your probation by failing to report as directed to the probation department July 2nd and July 17th of 2025. And is that true or not true?
True.
Count 8 alleges that you committed that new offense of deadly conduct on January 5th of 2026. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 and 8 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true?
Yes.
I also have some documents in this case that the state's marked as exhibit number 1 that have your signature on them. Before you signed these, did you go over them with Mr. Parker? And did you fully understand them as well? And you also understand, if I follow the agreement in this case, you'll also be waiving your right to appeal. State tenders number 1.
No objection.
It's admitted. In cause number 22-39186, I'm going to find that you entered your pleas of true to counts 1 and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you in each of these cases, they'll run concurrently, which means together at the same time, if I didn't already say that. I'm going to hand you in each of these cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. Also, I am going to find in cause number 22-39186 an affirmative finding of a deadly weapon. I'm also handing you the trial court a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You can go back with the bailiff. Thank you, ma'am, for being here. Sula Hamden. And it shows us for bond hearing, but it looks like there's an agreement. Is that?
Judge, it is an agreement, Judge. It's a misdemeanor.
Take 60 days.
You got one of the Snickers yet?
I think I might have one more. I have been going through them. It's only March and. All right, are you Sulu Hampton?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the motion?
Here we go, Honor.
Mr. Hampton, in cause number 24 DCCR 0759, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 7th of 2024 for a lesser offense of evading arrest or detention. I guess that really should say,
Yes, Your Honor, we should strike the with a motor vehicle.
any objection to
No
that
objection.
amendment? Did that. All right, so is the lesser offense of just evading arrest or detention a Class A misdemeanor? That was a 2-year deferred probation and has been extended for a year. Is that correct?
Yes, ma'am.
This motion alleges that you violated your probation. Count 1 alleges that you provided a urine sample January 21st of 2026 that tested positive for methamphetamine, amphetamine, and tetrahydrocannabinol. And is that true or not true?
Yes, ma'am.
True or not true?
True.
And then count 2 alleges that you failed to pay your court assessed fees as directed. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
Have some documents here on the tablet that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1,
No objection?
it's admitted. Is there any evidence that Mr. Hampton is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of evading arrest or detention. Sentence you in accordance with your agreement to a term of 60 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. All right, good luck to you, sir. You can go back to the bailiff.
Thank you, Your Honor. Thank you.
Carl Ledet, Carl Ledet, I'm sorry.
My first case in this bench, she can't even make me a reasonable offer. I settled with Tommy.
It's super aggravated. That is a reasonable offer.
So this is a 25 to life one. Yes.
I may not have checked it right on the thing, but
Okay, I'll make that
He does.
modification.
I'm whatever.
All right, sir, is it Ledet or Ledet? And you are Carl Ledet? And Mr. Ledet, and cause number 25 DCCR 0579, you're charged with a special degree felony of an aggravated assault of a child, aggravated sexual assault of a child, from August 1st of 2024. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be a minimum of 25 years up to 99 years or life in prison without the possibility of parole. Do you understand?
Yes, ma'am.
And I have here on the tablet a document that you signed with Mr. Parker, that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 30-year term in the institutional division of the Texas Department of Corrections, obviously with the opportunity for parole. You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial, what your options are. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay, we'll get that done. Ms. French, is there any reason to believe at this point that there would be any change in that offer?
No, Your Honor.
All right, so I do want to make sure you understand, Mr. Ledet, that after today, there won't be, this offer will be off the table. You understand?
Yes, ma'am.
So what, Mr. Ledet, Mr. Parker represents you now. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
So, Mr. Parker, you're released. Mr. Ledet, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Yes, ma'am. Thank you. Oh, nice.
All right, sir, you can go back to the bailiff. Travis Lewis, Mr. Parker.
Let's talk to them today if you come home.
That's
Well, no, not necessarily.
Today, I've come to the conclusion I do not have the temperament to be a judge. I've come to that.
Some days it takes a lot.
You wouldn't get my vote anyway.
Mr. Parker. I mean, we've been going, I'm still drinking coffee. It's cold from this morning. I haven't even finished my cup of coffee yet today. All right, sir,
Good.
Travis Lewis. And will your client waive the formal reading of the indictment?
He will, Your Honor.
The United States electing to proceed under 1244 of the Penal Code and punish this offense as a misdemeanor.
Thank you, sir. Mr. Lewis, in cause number 25 DCCR 0014, you're charged with the state jail felony offense of credit or debit card abuse, and that's from November 29th of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Lewis is not competent?
No, Your Honor.
All right, Mr. Lewis, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of credit or debit card abuse. Sentence you in accordance with that agreement to a term of 60 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. And I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
Yes. You got it. You should have. Thank you. Thank you. Here. Just, I think the last one, just need to go through the motion.
Mercedes Sias. I'm gonna have to take a break after this.
Got Pleasant on rusting out of bed.
I know, and he was happy.
He's excited. You gotta.
Oh, okay, then I'll wait a minute.
I
can, wait a minute.
Oh, no, more than.
Just gonna go through the motion. Just. Hold on. Right here.
Good morning.
Good morning.
Are you Mercedes Science? Answer out loud, yes or no, please.
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the motion?
Sure, Your Honor.
Ms. Science, best you can, raise your right hand for me. Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, ma'am. You can put your hand down. Ms. Science, in clause number 18-29442, I have a motion to revoke your community supervision. Shows that you were placed on probation January 7th of 2019 for the state jail felony offense of driving with a child passenger. And that was a 2-year term in the state jail prison that was probated for 5 years and extended for 2 years. Is that correct?
Yes, ma'am.
This motion alleges you violated your probation. Count 1 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
Yes, ma'am.
True or not true?
Yes, ma'am. I had a lot.
Listen,
True
Yeah,
or not?
true or not true?
True.
Thank you. And we'll go through the reasons and explanations at another date, okay? Today, I just need to know if it's true or not true.
Okay.
Count 2 alleges that you failed to pay your court-assessed fees as directed, and that as of December 11th of 2025, you were $6,707 behind in your fees. Is that true or not true?
True.
And count 3 alleges that you failed to make monthly fee payments in the minimum amount of $50 as directed by the court. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm going to reset your case for sentencing and ask the probation department to do an updated report. That'll give me more information about what's been going on since we were here last, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Parker, and he'll present it to me on your behalf when we come back.
Yes,
All right.
ma'am.
You can go back with the bailiff.
Okay.
Yes, not excused.
Thanks. Right. Miss- Can I? Imagine that.
Every case is one.
I didn't think I did. Yeah, somehow. Maybe I.
Have a good day. You too, Ms. Lounge.
Ms. Perazzo, you have Thaddeus McCray.
McCray.
Maybe so. And this is an MTRP final reset. So are we just going through the motion?
This is the one that committed murder when he was on this. This is the guy we tried with Bruce, and the victim wouldn't show back up, so we had to plead him to the other ones. We have put him on probation, and that's when he got out. He built a new girlfriend, and we still waiting on that to be brought over.
So y'all still don't have the murder?
Hasn't been brought to us.
So I did discuss with Mr. Smith possibly setting or asking for a PR bond. He is on deferred probation.
No,
But
it's on
according
straight
to
probation.
And just like that, another courtroom battle comes to an end, but the bigger lesson goes far beyond today's hearing. In the courtroom, every word matters, every decision has consequences, and your past can follow you into every new case. Whether you agree with the judge's ruling or believe a defendant deserved another chance, one thing is certain: the justice system demands accountability. What do you think? Did the judge make the right call, or was the sentence offer fair enough? Share your thoughts in the comments. We'd love to hear your perspective. If you enjoy real courtroom drama, legal breakdowns, and in-depth case analysis, make sure to hit that like button, subscribe, and turn on notifications so you never miss our next courtroom showdown. Thanks for watching, and we'll see you in the next case.